Welcome, everybody, to the first quarterfinal round of the largest international mock trial contest yet. There were 48 teams. We are now down to the Elite Eight, and we have assembled a very talented and experienced judging panel to determine who will move on to the final four. We're going to begin with our presiding judge, Judge Abigail Kim, who's going to take it from here. I'm, of course, joined by IMT/PPMT Administrator William Zhao, graduating from U Chicago. Without him, of course, this could not be possible. So best of luck to both teams. Thank you so much to William. Abby, the floor is yours. Take it away, Judge Kim.
Hi, everybody. My name's Abigail. I'm going to be presiding this round. I know you guys usually work with judge preferences, so I'm going to give you just like a really truncated version of my preferences. I go to UCLA. I compete for UCLA mock trial. That means I like sort of big, fun presentations. I like, fun, cool arguments. And overall, I just want to see you guys having a good time, being respectful to each other, and go out there today, take one risk. That's really all I want to see is you guys trying new things and having fun. You guys are going to do awesome. I've judged a couple of these rounds. This is a really interesting case. I'm really excited to see what you guys do with it. I'll kick it off to my fellow UCLA mocker over here, Kaylee Magno.
Hi everyone, I'm also a competitor here at UCLA. Do I give like a preference kind of thing like you did?
Whatever you'd like.
Yeah, kind of along the same line what Abby said. I mean, we go to the same school, so we have similar mock trial styles probably. But I really like to see people having fun, and just show me what you got. I'm really excited. Yeah.
Hi, folks. My name is Davia Cromer. I am an alum of the University of Southern California mock trial program, and a civil rights lawyer based in DC now. Yeah, I mean, I also grew up with that Southern California style of mock trial, but really excited to see you guys compete today. Excited to show off your knowledge, and as Judge Kim said, to hear you do it in a respectful way.
All right. And with that, before we call the case to order, I'm going to ask my fellow judges to make sure you guys are in speaker view and to hide all non-video participants just so you can see the competitors in all their glory. I'm sure you guys got that going on. So without further ado, we're going to call the case of State v. Wolf to order. Now, if we could get appearances from the prosecution and the defense at this time.
Yes, Your Honor. Good afternoon, Your Honor. My name is Anya, and today, alongside my co-counsel, Miss Kayla Hua.
Good evening, Your Honor.
We represent the state of Tilly.
All right, good evening. Defense, you guys have introductions?
Good evening, Your Honor and opposing counsel. My name is Iyad Kidwai, and today I will be conducting the direct examination of Nova Wölff, the cross-examination of Cotter Ashlock, and be delivering the closing statements on behalf of the defense.
Good evening, Your Honor, opposing counsel. My name is Sophie Sessa, and I will be delivering the opening statements on behalf of the defense, as well as the cross-examination of Larry Capolino and the direct examination of Charlie Reeves.
Thank you, defense. Prosecution, it's my understanding you might have a couple pretrial matters.
We do, Your Honor. First, we'd
right,
like
feel free to go.
Yes, Your Honor. First, we'd like to invoke Rules 603 and 615, constructively swearing in and sequestering all witnesses, barring party representatives.
All right, so invoked. Do you have any party representatives in this case?
No, Your Honor.
All right.
Next, we'd like to ask Your Honor's preferences on screen sharing exhibits or demonstratives. Would you like for us to ask for permission or simply state for the record?
Go ahead and state for the record. You don't need to ask for any permission.
Yes, Your Honor. And finally, Your Honor, we'd like to bring the court's attention to stipulation number 7, which states that the following list of exhibits are pre-admitted in its entirety: exhibits 2, 10, and 12.
All right.
And with that, Your Honor, we're ready to get this show on the road.
All right. Defense, do you have any pretrial matters?
Just briefly, Your Honor, we ask that all of the same rules apply to us as the defense.
Don't worry, they're going to apply to everyone equally.
Yes, Your Honor. And then we as the defense would like to also read a stipulation onto the record.
Okay.
Center for Academic Integrity versus Lobachevsky, 1955. Reasonable force in determining whether an action constitutes citizen's arrest is defined as force necessary, within reason, to prevent the escape of the arrested persons. And also, Your Honor, when an objection gets sustained, would you like us to ask for motion to strike, or will it automatically be stricken?
Ask to strike.
Yes, Your Honor. And with that, the defense is ready to proceed with opening statements.
All right. Prosecution, feel free to take it away.
May I begin?
I'm muted. You're good.
Thank you. May it please the court. She kidnapped to catch a killer. It's March 11th, 2025. And the defendant, a woman named Nova Wölff, is lurking in the shadows. She's watching and she's waiting for the perfect opportunity to strike. And she got it. Cotter Ashlock felt the hairs on his neck stand a moment before the defendant takes a swing at him, knocking him out cold. The defendant would then drag Mr. Ashlock to her basement, tying her up, torturing him till he's bruised and bleeding. Why? She believed Mr. Ashlock knew who her best friend's killer was, because she kidnapped to catch a killer. That's why we, the prosecution, are charging the defendant for unlawful imprisonment. This means that we have to prove two things to you today. One, that the defendant kidnapped Cotter Ashlock, restricting them without their consent. And two, that the defendant, a civilian, interfered with an ongoing investigation an officer was already conducting. And we understand that by stepping into the courtroom today, we've taken on a burden. The burden to prove beyond a reasonable doubt that the defendant unlawfully imprisoned Mr. Ashlock. Today, we're going to meet that burden because of two simple facts: the disregard and the detention. So first, the disregard. You'll hear from the on-site detective today about how the defendant ignored the warnings of the authorities and interfered with the official investigations into the Ashlock family. You'll learn how the defendant, a detective herself, constantly followed the case, despite the case not being hers. You'll hear how the defendant was obsessed and relentless, because this wasn't just a case to her, it was revenge. So second, the detention. The detective in today's case will also tell you that Mr. Ashlock was detained for longer than necessary, for this to qualify as a citizen's arrest. Mr. Ashlock will take that stand and explain how the defendant stopped him, sending threats and photographs. And you'll realize the evidence shows the motive she had to kidnap and interrogate Mr. Ashlock. She was desperate, so she kidnapped to catch a killer. Members of the jury, we get it. Losing a friend to gang violence is one of the worst things in the world. But it isn't an excuse to capture and torture someone else. That's why at the end of today's trial, my co-counsel, Miss Anya will come up for you again and ask that you give the only just verdict. Find the defendant guilty.
All right. Thank you, prosecution. Defense, would you like to present your opening statement?
Yes, Your Honor.
Feel free to go whenever you're ready.
May I proceed?
You may.
Nova Wölff drew the line. It's a late night on March 11th, and it was an oddly calm night. You see, for the past several years, the Ashlocks, a notorious crime family, patrolled the city of Corleone. They extorted businesses, bribed police, and even murdered innocent people. However, a woman named Nova Wölff decided enough was enough. She drew the line. She decided to help the police in removing the Ashlocks from Corleone. And Wölff was already a licensed private detective, so she put her skills to work. Wölff played a key role in taking that family down. She supplied tips, evidence, and clues that aided the police in removing the Ashlocks from that city. Even if they disliked her, and even if they disregarded her, Nova Wölff drew the line at injustice. There was one issue, though. You see, Cotter Ashlock was in Corleone to contact a former loyalist, and then he decided to stalk another victim later that night. They were so scared they ran to Wölff's house for help, and that's when Wölff recognized Ashlock as a dangerous criminal. And what she did next was a lawful citizen's arrest. She drew the line. In a mere 40 minutes, Cotter Ashlock entered Wölff's home, had the chance to leave, and he went back inside of his own personal will. Now, the prosecution may try to say that Wölff knocked Ashlock out, dragged him into a basement, and tortured him with a knife. But members of the jury, you'll find that the evidence doesn't match their story. You'll find that Ashlock's CT scan came back clear. No head injury at all. And you'll even find that the only fingerprints on that knife were Cotter Ashlock's. Throughout this trial today, the prosecution is going to call it biased witnesses and evidence that simply doesn't match the timeline that they're trying to prove to you. Now, members of the jury, the prosecution also has a burden to prove to you beyond a reasonable doubt. They have to prove to you that first, Nova Wölff falsely imprisoned Cotter Ashlock, and that while doing so, she interfered with the police officer. But members of the jury, they won't meet that burden today because they have to prove these charges beyond a reasonable doubt, meaning that if they leave any questions unanswered, any holes in any doubt, they will have failed to meet their burden. Now, as the defense, we are certain that Nova Wölff did a lawful citizen's arrest. In fact, members of the jury, we are so confident that we've taken on our own burden, the preponderance of the evidence. Now, our burden isn't the same as the prosecution's burden. While they have the highest burden in the court of law, all we have to prove is 51%. Think of it like a scale. If that scale tips even slightly in our favor, then we'll have met our burden. And we will meet that burden today, members of the jury, because today's case is about a criminal trying to save himself by blaming the one person who stopped him. Now, at the end of this trial, my co-counsel, Mr. Kidwai, will come up here and he'll ask you to find Nova Wölff not guilty. And you must, because the evidence presented in today's trial will leave you with serious doubts about Mr. Ashlock's story. When there's reasonable doubt, your duty is clear. You must find Nova Wölff not guilty. Thank you.
All right, thank you. Before we call our first witness, I'm going to take a couple seconds for me and my scoring judges to finish up comments. All right, let me know whenever you're ready. All right. Prosecution, do you have a case you'd like to present?
We do, Your Honor. We call Larry Capolino to the stand.
All right, feel free to begin your direct examination whenever you're ready.
Yes, Your Honor. Good evening, sir. Could you please introduce yourself to the court?
My name is Larry Capolino.
What do you do for a living?
I am a sworn officer with the Corleone Police Department, currently assigned to the Major Crimes Division.
And how'd you get into this line of work?
I've wanted to protect people ever since I was a child, and I figured that the best way I could do that was by serving my community as a police officer.
How are you qualified for this position?
I've served with the Corleone Police Department since 2011, and in that time I've been involved in over 50 felony cases involving organized crime and violence. My training includes advanced investigative techniques, evidence handling, and crisis negotiation.
So why are you here in court today?
I was the lead investigator assigned to the case involving Cotter Ashlock's alleged kidnapping on March 11th, 2025.
Well, let's talk about the beginning of your investigation. Before that, who is Cotter Ashlock?
He is a member of the notorious Ashlock family, one of the biggest crime groups in the region.
Do you know if the defendant had any history with the Ashlocks?
I've investigated their family for years, so I was aware that a former member of the Ashlock family, Jay Kuang, poisoned one of her best friends. Since then, he has doggedly pursued the Ashlock crime family.
Do you know if the defendant went after Cotter Ashlock?
I thought she might. So on March 6th, when Cotter Ashlock was released on parole the previous week, I called Wölff to warn him not to involve himself.
Do you know if the defendant involved herself with Cotter Ashlock?
Yes. Just a few days later, on March 11th at 11:35 p.m., dispatch received a call from Nova Wölff saying she had restrained Cotter Ashlock.
Would you recognize a copy of that transcript if I showed it to you today?
I would.
Your Honor, for the record, the prosecution is now screen sharing Exhibit 4C. Officer, do you recognize this?
I do.
Does it look fair and accurate?
Looks like it.
The prosecution moves to enter Exhibit 4C.
Any objections?
No objections to this exhibit, Your Honor.
All right, 4C is in evidence.
Yes, Your Honor. Officer, based on this exhibit, why did the defendant restrain Cotter Ashlock?
Looking at this, apparently she was trespassing on her property. After that, I drove with the team to Wölff's home, where we found a bruised Ashlock in her basement.
Does the defendant's story match with the victim's?
Not at all. Ashlock alleged he had been abducted while walking through Corleone town. He was struck from behind, tied to a chair in a dark basement, and interrogated by Nova Wölff.
What did the defendant interrogate the victim about?
Wölff demanded to know the location of Jay Kuang and threatened Ashlock with a knife, in addition to smashing Ashlock's phone.
Does this match the evidence you found?
Yes. In the basement, we found rope fragments, a damaged chair with red residue, and a phone believed to be Ashlock's. We also found a kitchen knife from the counter adjacent to the entry point to the basement.
Do you know if Cotter Ashlock and the defendant spoke in that basement?
Yes, they did.
Would you recognize a copy of a transcript?
I would.
Your Honor, for the record, the prosecution is now screen sharing pre-admitted Exhibit 2. Sir, what does this transcript tell you?
It says, I recommend you start talking to me, or you can talk to the police. It's clear that Ashlock was restrained and tied up. In addition, Wölff was trying to get him to talk and said,
Objection, Your Honor. Pursuant to Rule 602, this calls for speculation.
All right, explain.
Yes, Your Honor. This witness is testifying that Cotter Ashlock was tied up in Nova Wölff's basement. However, there's no direct proof, as this witness just testified that Cotter Ashlock was found in the basement, never tied up. The fact that this witness is testifying to Cotter Ashlock definitely being tied up in the basement calls for speculation, as this witness was not there while this perceived event happened. He only appeared after, and there's no evidence pointing that Cotter Ashlock was ever tied up, and that calls for speculation.
Okay, prosecution.
Yes, Your Honor. Co-counsel, if we could actually go back one slide and look at the full exhibit. Your Honor, I'd like to turn your attention to the very bottom, Ashlock's statement that says, "I want you to untie me before I spill a single word." Your Honor, we were about to have the witness testify to this direct statement Cotter Ashlock said, which he directly relied upon to infer very reasonably that she was tied up.
Okay, because this is a speculation objection, and I see this line here, and I also know that they found rope fragments in that basement. I believe this witness is using his rationally based perception. You can ask him about whether or not he actually saw this on cross. So I'm gonna overrule that objection.
Honor.
Yes, Your Honor. So, officer, can you tell us more about the evidence you found from this transcript?
Ashlock additionally says, "I want you to untie me before I spill a word." This heavily suggested that Ashlock was tied up while he was in Wölff's basement.
All right, so in this transcript, did the defendant mention calling the police after restraining Cotter Ashlock?
No. Instead, it seemed like she was trying to gather information instead of calling the police.
Well, let's talk about when the police finally got involved. Because, officer, was there an active police investigation into Cotter Ashlock?
There was.
Was the defendant on this case?
She was not. In fact, I asked her to not get involved.
So when the defense said the defendant drew the line and helped with the police, is that true?
No, it is not. She would give misleading or confusing answers repeatedly in an interview. For example, she said that Ashlock was both trespassing in her home and that she was restrained on the street.
So did she cooperate?
No, she did not.
Officer, how does delaying or obstructing information interfere with police work?
It reduces the ability of me and my fellow officers to conduct the investigation and might potentially lead the investigation in a wrong direction.
Thank you for your time today,
Objection, Your Honor. Pursuant to Kowalski versus Tilly, refusing to provide statements is not a sign that someone is guilty, and it violates the Fifth Amendment.
Okay. Okay. I have this case law pulled up. So explain a little bit more. How does the case law tie to what this officer just said?
Yes, Your Honor. This witness is saying that this witness directly interfered with the investigation at hand, and that directly violates case law, because just because Nova Wölff did not provide statements does not mean that she's guilty of interfering with a police officer, and that goes to violate Kowalski v. Tilly.
Okay. Prosecution?
Your Honor, that's not what the officer said at all. While we do agree that it would be a violation of the Fifth Amendment if he said, because the defendant didn't provide these statements, that's why she obstructed with the police, that would be wrong. But that's not what this officer said. He said that because she was giving misleading information and because she was interfering with an active investigation, those are all reasons that can obstruct police work.
Your Honor, if I may.
Sure.
That goes to directly prove Kowalski v. Tilly. Just because this witness isn't saying it outright, it's still implied that he's trying to prove guilt, which goes to case law Kowalski v. Tilly.
All right, prosecution, final word here.
Your Honor, this officer is not trying to take the role of the members of the jury and prove guilt, but instead offer his experiences as an officer and explain how citizens involving themselves with an active police investigation can interfere with the officer's work. For instance, if they are going around and kidnapping the suspect, that would interfere with their work, and delaying and obstructing this information is very harmful to their case.
Okay. Defense, your argument is well taken. I'm going to overrule it this time. We're going to issue a limiting instruction to the jury that this witness is not opining on the defendant's guilt for their lack of a statement at any given moment.
Yes, Your Honor.
Yes, Your Honor. So, officer, one more time, how does delaying or obstructing information interfere with police work?
If a witness says misleading or confusing information, or attempts to involve themselves in an active police investigation, it can hamper the ability of officers to collect evidence and interview witnesses. And this reduces the ability of me and my fellow officers to find the truth.
Thank you for your time today. Your Honor, nothing further.
All right, cross-examination?
Yes, Your Honor. May I proceed?
Whenever you're ready.
Now, Detective, you first encountered Miss Wölff in 2018 during the ongoing Ashlock investigations, correct?
Yes.
And she was a private detective.
She was.
So she never worked directly under your police department, correct?
Not that I was aware of.
Right, but she still provided clues that aided your investigation with the Ashlock family.
Yes.
Evidence that specifically put Cotter Ashlock into jail on a murder charge.
I believe that's right.
And Detective, when Nova Wölff performed a citizen's arrest on Cotter Ashlock, he had been violating parole since March 6th, correct?
I don't think that she performed a citizen's arrest, but that is right, that he was violating parole.
But that's what she told you, correct?
Yes, and I believe that she lied.
All right, Detective. So Cotter Ashlock was violating parole from the 6th to the 11th, correct?
Yes.
And you were aware of this. You got insider information that Cotter Ashlock was violating parole.
That's right, yes.
But you weren't able to catch him, were you?
I was not.
In fact, the only reason that you detained Cotter Ashlock was because of Nova Wölff's help.
That's right. But just because it helps the police doesn't mean it's legal.
But, Detective, on direct, you're asserting that she was destructive and didn't help your case at all. But she did, didn't she?
I believe that the harm that she caused during the interview and by kidnapping a witness, that she harmed it more than she helped.
So, Detective, you're saying that you would rather have a known murderer on the street than Nova Wölff detaining a known criminal that's been rampant that you hadn't caught?
I'd rather have witnesses not break the law to capture other criminals.
All right, Detective. Now, you said that Nova's and Cotter Ashlock's story didn't match up with each other, correct?
Yes.
And you're more prone to believing Cotter Ashlock's story, correct?
I'm more prone to believing what supports the evidence.
All right, let's talk about that evidence that you found. Your main pieces of evidence were a damaged chair, a phone, a knife, and rope fragments.
Yes.
And those items were obviously turned over to forensics.
They were.
And detective, in a police investigation, it's a regular activity to conduct forensic reports on these items.
No, I think it depends on the investigation.
But detective, when you have physical evidence, is it not common to test them?
I might, but it's not necessary.
Well, all right, detective. Your Honor, let the record reflect I'm now retrieving what has been previously marked as Exhibit 11. This is Exhibit 11, correct?
Looks like it.
And it's a clear and accurate representation to your knowledge?
Yes.
Your Honor, at this time, the defense now moves to enter in Exhibit 11 into evidence.
Any objections?
Yes, Your Honor. Hearsay.
All right. What's your issue, prosecution?
Your Honor, this is an out-of-court statement, an out-of-court document being used for the truth of the matter asserted.
All right. Defense.
Yes, Your Honor. Pursuant to Rule 8036, this is records of a regularly conducted business activity. In police investigations, it's common to use forensic reports in their investigations, and this specific forensic report is a regularly conducted business activity and is an exception under 8036.
Prosecution, do you agree?
No, Your Honor. As we all know, 8036 does have several prongs, including 8036A, that the record was made at or near the time the information was transferred. That foundation has not been laid when this record was made and what it's describing. 8036B, that the record was kept in the course of a regularly conducted activity. We believe Officer Capolino just testified that forensic evidence isn't that these forensic things gathered is not always necessarily tested, and it wouldn't always result in these kinds of forensic reports, which means this prong has not been fulfilled, as well as 8036C, which says that it is regular to conduct these activities. All these prongs are lacking before it can be admitted as such.
May I respond, Your Honor?
Sure.
Your Honor, it's common knowledge that when a forensic item is tested, the report is going to be fulfilled in that specific amount of time. This is a regularly conducted business activity because forensic reports are common in police investigations and is therefore a regularly conducted activity in police investigations in general, and therefore does still fall under the exception because it is a regularly conducted activity between the police force and is an exception under 8036.
Response to that, Your Honor?
Sure, you can have final word.
Yes, Your Honor. While we do agree that making these records can be common, that doesn't mean it is a regular practice of the police to always make forensic reports for every single case they open. Officer Capolino just clearly explained that it is not regular and it does depend on the case. And that foundation certainly needs to be laid before it can fulfill the majority of these prongs. But in addition, we still do have issues with 8036A, which shows that this specific record was made at or near the time the information on this, the evidence was gathered. These prongs need to be met.
All right. I see a date here on the document that is about right after when this incident occurred. So I don't have any 8036A issues. I don't think we necessarily need to meet the bar that every single piece of evidence ever has been tested by the police. It is my understanding that the police will make reports when they do such testing. So I'm going to let it in under 8036. Objections overruled.
Yes, Your Honor. Now, detective, looking at this exhibit, the main pieces of evidence are the fingerprints on the knife and the phone, correct?
Yes.
Now, what Cotter Ashlock told you is that Nova Wölff was holding a knife at his head and threw the phone on the ground, correct?
That's what he said. Yes.
Now, detective, if you'll read right under the knife, it says that all of the fingerprints match to those of Cotter Ashlock, correct?
Yes, the partial fingerprints matched.
Yes, detective, and that no other matches were made.
Yes, that's right.
And then in the comments, it says that the knife it's unlikely that it got wiped down because of the amount of fingerprints that they were able to pull off, correct?
That's what it says.
And also, detective, it's likely that the knife belonged to Cotter Ashlock because of the amount of fingerprints on that knife.
Yes.
And then if you look right below at the phone, just like the knife, the only fingerprints on that phone were Cotter Ashlock's.
That's what it says. Yes.
So, detective, the forensic evidence goes directly against what Cotter Ashlock had told you.
Yes, it does go against the evidence, but I found more evidence to support Cotter Ashlock's story, so that's how I conducted my investigation.
Detective, the only other physical evidence that you found were a damaged chair and rope fragments. Is that correct?
I also found evidence in witness testimonies, which in cases like this can often be more important than physical evidence.
But detective, as a detective, you know that witness statements can often be unreliable in criminal cases.
Yes.
Now, you also learned from Cotter Ashlock that he claimed to have a head injury. Nova knocked him out, correct?
That's what he said.
All right. Your Honor, let the record we're now screen sharing what has been previously marked as Exhibit 9. All right. This is the medical report that you looked at when you were going through this case, correct?
It looks like it, yes.
And it's a clear and accurate representation?
Yes.
And if you don't mind, can you just confirm the name of the hospital and the title of the report, please?
It says St. Alfonso Hospital Incident Admission Report.
Yes. Your Honor, at this time, the defense now moves to enter an Exhibit 9 into evidence.
Prosecution, any objections?
No, Your Honor.
All right, so admitted.
All right, so again, detective, Cotter Ashlock claimed to have a head injury so severe that it knocked him out, correct?
That's what he said.
All right, detective, let's look at that injury summary right below the clinical information. It says that no contusions to the head were found and that it conflicts with the patient's claim of being hit on the head.
Yes, I found it strange because there's also no mention of the many bruises I found on Cotter Ashlock.
Right, there were no bruises found on that report.
Yes, it was strange because I clearly saw him covered in bruises.
All right, detective. Well, let's read at another small detail that they noticed, that the patient is right-handed and that there were contusions to the right knuckle, correct? That indicates that Cotter Ashlock could have been punching someone or something.
Could have been doing anything with his hands.
But it indicates that he was punching someone or something, detective.
It says it could indicate.
All right, detective. So just to sum it up, you have no physical evidence or direct evidence pointing that any story of Cotter Ashlock's testimony is true today.
No, I do. The transcript of the phone heavily supported Cotter Ashlock's story and directly discredited Nova Wölff's.
But detective, none of the actual physical evidence that you found on that scene aligned to Cotter Ashlock's story today.
A recording of the event is physical evidence.
The forensic evidence and the physical evidence of Cotter Ashlock being hit on the head does not match to Cotter Ashlock's story.
Yes.
Those are three major indicators that disproves Cotter Ashlock's story today in court, doesn't it?
That's right.
No further questions. Thank you, Your Honor.
Thank you, defense. Prosecution, any redirect of this witness?
Yes, Your Honor.
All right.
Officer Capolino, I want to give you a chance to explain all the evidence you found. What indicates Cotter Ashlock's story is true?
The most important piece of evidence I found that would indicate that is the transcript of the recording. In that, Nova Wölff says that she won't call the police if Cotter Ashlock answers the questions. This completely goes against Nova Wölff's assertion that it was a citizen's arrest and heavily supports Cotter Ashlock's statement that she was kidnapped to be interrogated.
Did Cotter Ashlock have any visible injuries?
Yes, he was covered with bruises.
Did that show up on his medical report?
No, it didn't.
Thank you, officer. Your Honor, we have nothing further.
All right. Any recross based on that?
Very short, Your Honor, if I may.
Okay, sure.
Now, Detective, the only instance of physical evidence that you have proving Cotter Ashlock's story is that short transcript, correct?
I also found rope fragments near the chair, which would suggest that someone was tied up.
But you also have evidence that Cotter Ashlock was violent before, as he had bruise marks and scratches on his right fist, indicating that he was punching someone or something.
A doctor said it might indicate that.
And the doctor today has no involvement in today's case?
I don't know.
Detective, the doctor is not testifying in today's case, correct?
I don't know.
All right, Detective, you have no physical evidence tying Nova's hands to that knife or that phone, correct?
Objection, Your Honor. This does fall outside the scope of redirect examination, if I may be heard.
Sure, prosecution, you go first.
Your Honor, the questions we asked Officer Capolino were specifically about Cotter Ashlock's medical examination and what sorts of evidence he had that indicated his story is true. Nothing about Nova Wölff or the defendant.
Defense?
Yes, Your Honor, the scope of that redirect was talking about the direct or the evidence that they had to prove Cotter Ashlock's story, and it's within my scope for a recross to disprove that evidence that they brought up on their redirect.
I tend to agree, since you asked a very broad question on redirect, it is within the scope. I will say, I think this recross is maybe getting a little long, and I know you guys have a limited amount of time, so just keep it short for the rest of this recross.
Yes, Your Honor, I'll only have one more question.
So overruled.
All right, Detective. Now, with the forensic evidence that I showed you in the previous exhibit, the knife and the phone, that does not match with Cotter Ashlock's story, yes or no?
It does not.
No further questions. Thank you, Your Honor.
All right. Mr. Capolino, you may be excused. Prosecution, do you have any further witnesses?
Yes, Your Honor. The prosecution calls Mr. Cotter Ashlock to the stand.
All right. Feel free to begin your direct examination whenever you're ready.
Good evening, sir. Could you please introduce yourself to the court?
Good evening, everybody. My name's Cotter Ashlock.
What do you do for a living?
Well, right now, I'm actually in school. I'm studying to become a guidance counselor for ex-convicts.
Why do you want to get into that line of work?
Well, I spent some time in prison because I used to work with my family's gang. I don't want anything to do with my past, but I think that it's important, and we need to talk about it. And that's why I want to help people like me to do that.
Mr. Ashlock, why are you in court here today?
Nova Wölff kidnapped me, and I'm here to tell you what really happened that day.
How do you know the defendant?
Well, I don't know her personally, but our family, well, we killed her best friend. My cousin, Jay. He was the one to do it.
So what happened after that?
Well, Nova started following us. At first, it was harmless, but eventually, she escalated.
How did she escalate?
She started leaving us threats. One time, I remember receiving a package with a bloody blade in it, and there was a note attached to it. Sometimes there was a note, and other times, well, it was an email.
Would you recognize an email if I showed it to you today?
From Nova Wölff? I would.
Let the record reflect that we're going to be screen sharing what has been pre-marked as Exhibit 12B.
This
Sir,
is an
my apologies, sir. But what is this?
this is an email that Nova Wölff sent me.
Does it look fair and accurate?
Yes, it does.
Let the record reflect that Exhibit 12B is already in evidence.
All right, record shall so reflect.
What does this say?
Well, it says, I will hunt you down to the ends of the earth if it's the last thing I do.
Did the defendant mention anyone else in this email?
She
Anything
sure did.
else in this email?
She sure did. When I responded to her, she told me, if I ever get my hands on any one of you, I will tie you up and torture you until you beg me to kill you.
So, Mr. Ashlock, how do you know that it was the defendant who sent this email?
Well, the email was signed the best friend of the man you murdered in cold blood. That's Nova. And when I called her Nova, she responded to me.
Sir, I want to turn your attention to March 11th, the day of the crime. What were you doing that day?
Well, I was in Corleone looking for Jaden, my cousin, the one who murdered Nova's best friend. For some reason, I thought he'd be in Corleone. Eh, I wanted to go see him, but I couldn't find him.
What happened next?
Well, on my way back home, Nova just came out of nowhere. One moment I was walking home, and the next thing I know, she snuck behind me, and I feel something cold and hard hit my head. And I passed out.
What happened when you woke up?
When I woke up, I was tied to a chair, and there was a piece of duct tape over my mouth. I was in a cold and dark room, and when I looked up, it was Nova, just right there, standing over me.
Did she do anything?
Yes, she did. She started asking me questions about someone named Jay Kuang. Jay Kuang who killed her best friend. She wants to know everything about him. But I don't know a Jay Kuang. I couldn't answer her questions.
Mr. Ashlock, looking back, how did you feel when the defendant kidnapped you?
I've been in this business for a long time. I've seen guns, I've seen poisons, I've seen violence, and I've even seen death. But I've never been helpless. And sitting in that chair in Nova's basement, ma'am, I felt helpless.
No further questions, Your Honor.
All right, cross-examination.
Yes, Your Honor. Permission to proceed?
Whenever you're ready.
Now, Mr. Ashlock, you're a part of the Ashlock crime family.
Good evening. And yes, I used to be at least.
Well, Nova Wölff is actually infamous within your family.
I would say that. She's been following us for quite a long time.
But everything she ever did to your family was perceived as harmless.
I wouldn't say harmless. She sent threats to kill and torture us in email and in the real mail.
I'm sorry, is it your testimony that Nova Wölff wasn't harmless?
She was harmless, but there were threats.
So she was harmless.
Yes.
Well, then, I'd now like to talk about the night of the 11th. You were in Corleone town that night.
I was looking for my cousin.
And you knew that by being in Corleone, you were breaking parole.
I was on my parole, and by being outside of the town I was supposed to, I did break my parole.
So you were breaking parole by being in Corleone?
Yes, but again, I just really wanted to see my cousin.
Exactly, you were looking for Jaden Ashlock.
That's correct.
The same Jaden Ashlock that betrayed your family?
Yes, that same one.
And then later that night, you actually had an altercation with Nova Wölff.
I wouldn't call it an altercation. He hit me and he kidnapped me.
Right, she allegedly hit you on the head and knocked you out.
Yes, she knocked me out.
But when you went to the hospital, the medical examiners found no trauma to your head.
I wouldn't know.
You wouldn't know about your own medical exam?
I don't know what they found. Sir, I'm not a doctor.
I'm sorry, you went to the medical examiners and you don't know what they found?
I couldn't tell you exactly what they found, sir. I
All
wasn't.
right, well then, let's move on. You say that Nova Wölff kept you in your basement.
Not in my basement.
In her
In
basement,
Nova
I'm sorry.
Wölff's basement, yes.
Yes, you say that Nova Wölff kept you in her basement.
Yes, I do. She did.
And you actually recorded part of your time.
I did record.
Your Honor, let the record reflect we're now screen sharing what has previously been admitted as Exhibit 2. Now, in this interview, Wölff actually gave you the option to leave and go to the police whenever you wanted.
In this snippet of the conversation, yes. But there was much more threats that happened that weren't caught on camera or under the recording.
I'm sorry, but you had the option to leave whenever you wanted?
No, I didn't. Again, I was restrained. In this specific recording, she says that I did, but I didn't.
Right, so the person restraining you told you she would let you leave whenever you wanted?
She says that, but it wasn't the case. If you see in this transcript, I ask her to untie me. I was restrained during this recording. I couldn't leave whenever I wanted if I was tied to a chair.
I mean, she told you that you could leave whenever you wanted, and then you asked her to untie you.
Again, she told me that, but I was not free to leave. I was tied. Yes.
Well, Mr. Ashlock, you actually never showed any indication that you wanted to leave because you told her you'd spill a word after she untied you.
Well, no. I said that I wanted her to untie me. I was trying to leave, sir.
Right, but you say I want you to untie me, and right after you say before I spill a word?
That is what I said, but I wanted to leave, sir. I was being restrained against my will in Nova Wölff's basement.
Right, but you said that you'd stay and talk to her?
I said that I would, before I spill a word. I don't think that means that I would stay and talk to her.
So you telling her you're going to spill a word doesn't mean you're going to talk?
Your Honor, asked and answered.
Technically, it isn't, so I'm going to overrule, but move the questioning along.
Yes, Your Honor.
Mr. Ashlock, one last time for clarity's sake, you had the option to leave whenever you wanted.
Nope. I was tied to the chair and I was restrained. I did not have the option to leave. She might have said that, but it wasn't the case.
So Nova Wölff, the person restraining you, told you you could leave whenever you wanted, yes or no?
She said that, but it was not the case. She said it, correct.
She said you could leave whenever you wanted?
She said I could, yes, but I was not. That was not the case.
You know what, Mr. Ashlock? I have no further questions.
All right, any redirect based on that?
No, Your Honor. No redirect.
All right, Mr. Ashlock, you're excused. Prosecution, have any more witnesses?
No, Your Honor. The prosecution rests.
All right, let's take a 5-minute break. We'll be back at 6:07 for the defense's case in chief. All right, are both prosecution and defense back and ready to go?
Yes, Your Honor, the defense is back and ready to go.
The prosecution is as well.
All right, defense, do you have a case?
Yes, Your Honor, we do.
All right, feel free to call your first witness.
Yes, Your Honor, the defense now calls Charlie Reeves to the stand. May we proceed, Your Honor?
Whenever you're ready.
Yes, Your Honor. Good evening, Miss Reeves. Could you please introduce yourself to the court?
Oh, good evening to you too, dearie. My name is Charlie Reeves, and I am too old to be looking this good. You see, I moved over to Corleone to enjoy my detective novels. Oh, and after some failed attempts to marry off my nephew's kids. You know, darling, you are quite beautiful. I might be pushing my luck here, but are you single by any chance?
We can discuss that later, Miss Reeves. Now, what did you like to read?
Oh, goodness. What didn't I like to read? You see, since I was a little girl, I was obsessed with Ellery Queen's novels. Oh, but I was more into Agatha Christie as I got older, of course. Oh, but my favorite will always be The Judas Window. Sorry, here I go rambling again.
Well, besides your hobbies, what else do you do?
Oh, honey, I'm retired now, and I have been for the last few years. You see, I used to be a taxi driver in New York, and it is taxing. No pun intended. You see, I decided to move out my busybody city and come over to Corleone.
Well, did you meet anyone new in Corleone?
Oh, I have a good story for this one. You see, it was my first day moving in, and I was out of sugar. So I went to my neighbor, Nova Wölff, and asked for some. The sweet thing lent me the whole bag. I mean, I knew just then and there that I had to have her over for dinner sometime.
Well, did you ever end up seeing her again?
Oh, yes. In the following days, I often came to borrow things from Nova. You see, I would bring some groceries or leftovers from dinner, and the sweet thing would always let me in. I mean, I honestly started to think of her like my nephew's sons, kind of like my grandkids.
Well, did Nova ever tell you anything about Corleone?
Oh my, mostly quite beautiful things, that it was a great city, except for that Ashlock family. I mean, I heard all about them and I was so relieved that I moved in when I did, long after they were caught. I mean, my Nova actually helped in the investigation to catch them. It was amazing to find out that she was a real life detective, since I loved detective novels.
Do you know why Nova lives in Corleone?
She moved just a couple years ago to catch the Ashlock family, and she used those detective skills of hers and kept our street safe.
Well, Miss Reeves, have you ever seen a member of the Ashlock family?
Unfortunately, I encountered Cotter Ashlock on, what was it, March 11th.
Well, what happened on March 11th?
It was around 10:30 p.m. and I was walking home when I could hear someone following me. I mean, I couldn't make out their face, but I was terrified. So I went over to Nova, and I'll admit I was a bit panicked, so I banged quite loudly on her door, but she came outside, told me she'd handle it, and I went right back in. That's when I heard her yell Ashlock, and I realized that it was none other than Cotter Ashlock. I mean, he had just been released on parole for all his crimes 5 days ago, and he was already violating it.
Well, did you see anything after that?
I knew I should have minded my business, but I mean, such a scary criminal was outside for goodness sake, and my stickler for detective novels got the best of me. So, yes, I did see some shocking sights.
Well, what did you see?
It, you see, I saw Cotter Ashlock come bursting out of my Nova's front door when I was watering the plants. And Ashlock was just in the driveway for a moment. Nova came out, and then Mashlock soon ended up walking right back in. It was the oddest thing, truly.
Well, what happened after that?
Oh, after a few moments of this horribly eerie silence, I heard my Nova yell, "You have a knife?" I mean, it scared me half to death. My heart is pounding thinking about it. I thought it was almost my time, but I had to pay attention. My eye for detective novels had really sharpened my eye for detail.
Well, did you hear anything else?
Oh my goodness. I heard Nova scream, "Let go and stop." It was horrifying. I heard the sounds of some glass shattering, someone fall into the floor, furniture scratching, things being knocked over. I never want to hear something like that again.
Well, Miss Reeves, do you know if Nova Wölff was okay?
Oh goodness, I hope so. I really hope Ashlock didn't hurt my Nova. I could never forgive myself.
Thank you, Miss Reeves. Your Honor, at this time, we have no further questions.
All right, cross-examination.
Yes, Your Honor. Miss Reeves, let's talk about the defendant.
Go
You
ahead.
would say that you and the defendant are close,
I would. She was a great neighbor.
good friends.
Yeah, honestly thought of her as my granddaughter at some points.
Right. And so today, you would say that you're testifying in this court for a good friend that you might call your granddaughter, correct?
I am. I'm testifying because I don't want her to get hurt like that again.
Right. So that's a yes to my question, ma'am?
Yeah, I am testifying for a good friend who was hurt on March 11th.
Right. And being her good friend, you learned that she had moved to Corleone for revenge, right?
Yeah, I did. She wanted to catch the Ashlock family, and she did.
Revenge against the Ashlock family. Yes.
Yes, for their crimes in Corleone.
Because they killed her best friend.
They did. They did some horrible things.
Ma'am, that's a yes to my question?
Yeah.
She was committing revenge against the Ashlock. She was there for revenge against the Ashlock family because they killed her best friend.
Yes, she is a detective after all. Used her skills.
In fact, the defendant would also talk a lot about the Ashlock family, correct?
Yeah, she did. I mean, she moved here just to catch him.
Her eyes would light up whenever she did?
Yeah, she wasn't as scared as the rest of them. I could tell she was ready to uphold the law against him.
Right, she wasn't scared. She'd even get excited.
Yeah, she had this look in her eye. I knew she was prepared to catch him.
She'd get excited talking about reporting information about the Ashlocks to the police.
Yeah, we're all excited after our jobs, after all.
Right, and she'd be excited talking about how closely she works with the police to bring justice, right?
She was.
And she never seemed to get excited about any other suspects than the Ashlocks.
Suspects to what?
Just any other suspects on cases she worked on.
I mean, she was a private detective. We didn't really talk about the details, so I'm not sure how excited she was for other people.
Right, but from your experience and your conversations, she never seemed to get excited about any other people that the Ashlocks.
Objection, Your Honor. Pursuant to Rule 602, this calls for speculation, if I may.
Sure.
Yes. Well, this attorney is not constantly with Nova Wölff. This witness, apologies, is not constantly with Nova Wölff and cannot testify to how excited or unexcited she would be with other suspects because Miss Charlie Reeves isn't constantly with Miss Wölff and is not constantly talking about other potential like criminals or suspects in other investigations. So it calls for 602.
Your Honor, response?
Sure.
The defense seems to have some misconceptions about my question. My question was to simply ask that when this witness was talking to the defendant, that the defendant didn't seem excited talking about any other suspects other than the Ashlocks.
Okay. Based on that, and because it's cross-examination, this witness can sort of respond to what they know. I'm going to overrule it this time, but if the line of questioning gets into whether or not the defendant was more or less excited about specific things, definitively, feel free to re-raise.
Yes, Your Honor.
So, ma'am, I'm going to re-ask my question. The defendant never seemed to get excited about talking about any other suspects than the Ashlocks.
I don't know. We didn't talk about really anyone else. She's a private detective.
Okay, ma'am. Let's move on to what happened on March 11th, 2025. I just want to compare what you can tell us to what the defense attorneys may be saying today. You were walking home?
I was walking home at around 10:30.
And you felt like someone was following?
Yes, Cotter Ashlock.
But you didn't hear their voice?
No, I didn't. I found out it was Cotter Ashlock once I went inside and I heard Nova scream, Ashlock.
Right. And you also didn't see their face?
No, I did see Ashlock's face when he ended up coming outside the house just a little bit after this.
Yes, ma'am. But before that, you didn't see their face?
No, until he ended up coming out just moments later.
And you didn't turn around to look at them at any point?
Oh no, I was horrified, truly.
And once you got back into your home, you didn't look outside at any point to see who it was?
Oh, no. As much as I love detective novels, I was quite scared in the moment.
But you can't confirm that you were being followed by Cotter Ashlock on that day at all, can you?
I can. Just a few moments later, Ashlock walked right out the house, so I do think it was Ashlock for sure.
But you can't confirm that it was Cotter Ashlock's intent to follow you on that day at all.
Well, I don't know. I can't. I don't know Ashlock's intent, but he was following me.
All right, ma'am. You told us you heard a struggle, but you can't tell us who started it, correct?
No, the first thing I heard was Nova say, "You have a knife," but that was it.
Right. And you also can't tell us who was holding what objects inside that house.
No, other than Nova saying, "You have a knife" at Ashlock. I don't know what they were holding.
So, Ms. Reeves, you can't tell us anything that happened inside that house, except for the sounds that you heard.
Yeah, I didn't see anything with my own eyes, thank goodness, but I did hear a lot. The walls are paper thin in our neighborhood.
All right, ma'am. No further questions, Your Honor.
All right. Any redirect?
No redirect, Your Honor.
All right. Miss Reeves, you're excused. Defense, do you have any more witnesses?
Yes, Your Honor. The defense now calls Nova Wölff to the stand.
All right, feel free to begin your direct examination whenever you're ready.
Yes, Your Honor. Good afternoon. Could you please introduce yourself to the court?
Hello, my name is Nova Wölff. I'm a girl, by the way. I know there's been some confusion. I'm a private detective certified by the Tilly's Detective Association, and I live in Corleone Town. I moved there several years ago.
Well, why did you move?
I had a good friend, Mark Volkovich, who used to live in Corleone Town. One day he was found dead in his restaurant, and later, an Ashlock pled guilty to his murder.
So is that why you moved? For revenge?
See, some could say it's revenge, but I'm not a vengeful person. I moved to Corleone Town because I wanted to protect other innocent victims like Mark from being hurt. And to me, the easiest way to do that was to expose the crimes of the Ashlock family to the police.
Well, how'd you do that?
I did whatever I could to aid law enforcement. I mean, I gave them anonymous tips about the Ashlock family's whereabouts, base camps, and just any other crimes they committed. They were actually able to arrest Cotter Ashlock because of the details I provided.
Now, Miss Wölff, during your deposition, you were shown a picture of your email.
Yeah, apparently Cotter Ashlock thought that I had been threatening him.
Your Honor, let the record reflect we're now screen sharing what has previously been admitted as Exhibit 12A. Now, Miss Wölff, is this your email?
I mean, it looks to be. n.thewolf@cmail.com.
And you were also shown some emails that you allegedly sent to the Ashlock family.
Yeah, I was, though I don't really remember sending them. The first time I ever saw them was during my deposition.
Your Honor, let the record reflect we're now screen sharing what has previously been admitted as Exhibit 12B. So, were these emails sent by you?
Well, like I said, I don't exactly remember sending them, but looking at it now, this was sent by a different email. The email you just showed me was n.thewolf@cmail.com, but this was sent by someone going by n.thewolf. No dot.
So, these were sent by a different person.
I mean, yeah, the emails are different.
Well, then, I'd now like to talk about the night of the 11th. What happened?
On the 11th, late at night, my neighbor Charlie Reeves came to my door in tears. She was clearly shaken up about something. See, Charlie kind of reminds me of my grandma, so I feel a little protective over her. When I saw her in such distress, I mean, I knew that something was wrong.
Did you find out what was stressing her out?
She told me that someone was following her. I told Charlie to just go back home and that I would handle the situation.
How'd you handle it?
Well, when I went to go see who it was, I found out that it was none other than a member of the Ashlock family, Cotter Ashlock. At that moment, I just remembered what happened to Mark, and I knew I couldn't let the same thing happen to Charlie.
So, what'd you do?
I needed to restrain Ashlock before he could do any more harm, so I decided I would make a citizen's arrest.
What's a citizen's arrest?
It lets anyone use the force deemed necessary to
Objection, Your Honor. Improper expert testimony under Rule 702.
Okay, explain.
Yes, Your Honor. Considering how Miss Wölff here is a lay witness and there's been no prongs laid that she's able to testify to what is a citizen's arrest and the nature of it, that means this testimony is not admissible.
All right, defense.
Yes, Your Honor, it's in the name, citizen's arrest. My witness is a citizen. It's within her rights and her knowledge as a citizen to know what a citizen's arrest is and how to perform one. Therefore, this is within her knowledge.
Response, Your Honor.
Sure.
I'm a citizen, and I'm sure you are as well, and I do not know at all the nature and the specific prongs of citizen's arrest. Now, while we agree, just saying the word citizen's arrest does seem pretty intuitive, Your Honor, as we have explained through opening statements, there actually are specific prongs that must be met, things that fall beyond the scope of a lay witness's knowledge.
All right, defense, last response.
Yes, Your Honor, just because opposing counsel isn't an upstanding citizen and doesn't know her rights, that doesn't mean my client doesn't. She's a citizen. She knows how to commit a citizen's arrest. It's within her knowledge and her rights as a citizen of the USA to know how to do that. Therefore, this is admissible today.
Your Honor, if I may have just one more word.
Okay, last word.
Yes, Your Honor. Even if we were to say she does have this knowledge, there has been absolutely no foundation laid on the record how she obtained the knowledge that she does have these rights and of the sorts, Your Honor.
Okay. Based on this new lack of foundation argument, I don't believe this is some sort of expert testimony. I think there can be foundation laid as to how this witness knows what a citizen's arrest is because it's a little bit more of a specific legal idea. So I'm going to sustain the lack of foundation objection.
Motion to
Yes,
strike,
Your
Your
Honor.
Honor.
Pending foundation, yes.
Yes, Your Honor.
Now, Miss Wölff, could you tell us a little bit about your job?
I'm a private investigator, so, I help specific people with their cases and yeah.
And what are some type of stuff you have to do as a private investigator?
Well, it's sort of like detective work. Someone comes to me with an issue, so I go and I investigate the scene, I find potential suspects, and being a private investigator, you have to know a lot of the law.
And one last question. It might sound a bit weird, but are you a citizen of the USA?
Last time I checked, I was.
Now, could you tell us what a citizen's arrest is?
Like I was saying earlier, a citizen's arrest allows someone to use the force deemed necessary to restrain a person suspected of committing a crime. Since I saw Cotter Ashlock violating parole, it was within my rights to arrest him.
So, what did that arrest look like?
Well, I saw Ashlock on the street, so I knew I just had to restrain him to the best of my ability. I decided that the best way to keep him put was to just have him inside my house.
I'm sorry, so you kidnapped Ashlock?
No, he
Pleading,
had.
Your Honor.
I think I think that's not the conclusion that they're going to come to, but I would keep some of the testimony off the record. So overruled right now.
Yes, Your Honor.
So, Miss Wölff, did you kidnap Ashlock?
No, he had the option to leave. In fact, he did. He ran out of my house at some point.
Well, then, if he had the choice to leave, how was this an arrest?
See, if the situation doesn't call for it, then a citizen performing a citizen's arrest doesn't need to necessarily physically restrain someone. Obviously, if they don't, then the criminal's probably just going to run away. But a verbal indication does also count as a citizen's arrest.
So, did you ever give him any type of verbal indication?
I did. When he ran out of the house, I reminded him of this citizen's arrest, and I told him that if he left, I would just call the police on him. After that, he eventually came back inside. At the time, I thought that it might be because he didn't want to waste energy running around Corleone trying to escape the police. But with the way he was acting later, I think he may have had ulterior motives.
Objection, Your Honor. Calls for speculation, specifically to that last line, if I may be heard.
Sure.
Your Honor, the witness said something along the lines of, based on the way he was acting, I thought he might have had these ulterior motives. Your Honor, that is clearly the mindset of the other witness, and that's speculation.
Defense?
Yes, Your Honor. The exact wording was based off the way he was acting. that indicates that pursuant to Rule 702, or 701, it's within this witness's rationally based perception to believe this. Additionally, if I may proffer, I'm just about to ask this witness what Cotter Ashlock was doing to make her believe this.
Okay. If you are going to lay that foundation, I'll overrule prosecution if they get into sort of what those ulterior motives might be, or if you don't believe that foundation is sufficiently laid, feel free to re-raise.
Yes, Your Honor.
I'm sorry, so Miss Wolf, how was she acting to make you think that she had ulterior motives?
Well, once we went back inside, Ashlock started lashing out. I mean, he was throwing punches, breaking everything around him, grabbing at me. At some point, he pulled a knife. He tried to swing it, but he went off balance and hit the ground with a loud thud.
What happened when he fell?
Well, if you take a look at me, I'm not exactly that strong. I mean, I know the trench coat adds a bit of shoulder, but I'm no muscle man. I had to protect myself, and Ashlock was completely out of control. So I just grabbed some nearby rope and I tied him up so that he couldn't cause any more damage. After I did that, well, then he just started acting weird.
What do you mean by weird?
He started blurting random nonsense, saying that I was threatening him and repeating myself. For the record, I didn't do any of that. And then he dropped his phone and smashed it with his foot.
So, did you not call law enforcement?
Listen, at this point, Ashlock was clearly still aggressive, and I didn't want any police getting hurt. I had to wait a couple of minutes for him to calm down before I called the police.
And what happened when the police arrived?
I made sure to untie Ashlock first, and then I just answered some other questions. And additionally, while Ashlock was restrained, I managed to get some information about the Ashlock family, so I passed on whatever I learned to the police.
Now, just to be clear, did you commit a citizen's arrest?
I did.
And did you interfere with law enforcement?
No, I gave the police information and I turned in Cotter Ashlock.
Then if that's the case, why are you in court today?
That's the thing, I don't even know why. I never thought that I would get arrested for following the law. But here I am today.
Thank you, Miss Wolf. I have no further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Good evening, ma'am.
Good evening.
I want to set a few facts straight. You hate the Ashlock family.
I hate any criminal that causes violence around town, yeah.
You hate them specifically because a former member killed your best friend.
That adds on to my hatred of criminals, yeah.
You've wanted revenge against that killer for years.
I wanted justice and I wanted to protect the streets of Corleone.
And by protecting the streets, you wanted to get that killer off it.
As any normal person would.
The killer went into witness protection.
Yes.
And since then, you've been tracking down members of the Ashlock family.
Yes, I keep close tabs on them to make sure they're not doing anything wild.
Hoping they could point you in the direction of the killer.
Of which killer?
The killer who killed your best friend.
Sometimes I glean useful information about him, yeah.
That sounds like a yes.
I did say yes.
All right, well, let's talk about the emails you brought up a moment ago on direct examination. And ma'am, you were questioned by the police.
Yes.
The police asked you about these emails.
They did.
And now right here in court, you had a very interesting story. You're saying these aren't your emails.
They're not. It's a different email.
You're saying N. Wolf. That's not your email.
No, it's N the Wolf in these email chains, but like I was saying earlier, I recognized only the N dot the Wolf.
You're saying the best friend of the man you murdered in cold blood. That's not you.
It's clearly someone impersonating me. I didn't send that email.
Okay, you're claiming right now somebody impersonated you.
It had to have been.
But when the police showed you these emails, you didn't immediately explain, these aren't mine.
I told them that I don't remember sending them, which is true.
You told them you don't remember sending it. You didn't tell them these emails are not mine.
I didn't because I already told them that these emails, I don't remember sending them. I feel like that's a pretty clear indication.
You made it much more clear today in court. You think someone's impersonating you.
I mean, yeah, I'm in court today. I feel like I should make things pretty clear.
And you didn't think you had to be more clear to the police that somebody might have been impersonating you.
They asked me if these emails were mine or if I remember sending them. I told them I don't remember sending them. I thought that was it, but I guess I have to further clarify now.
Okay, well, let's move on to other things you did when you went outside of the law. But first, let's set the scene. It's March 11th, 2025, and you detain Cotter Ashlock.
Yes.
You are in your basement.
Yes.
Cotter Ashlock is tied up to a chair with rope.
After he was lashing out at me, yes.
I just want to get your story straight. You are a detective who has been hunting the Ashlocks down for years.
Yes.
You come across Cotter Ashlock and he chooses to come down to your basement.
I restrain him on the street and I kind of shove him into my house. At that point, he had ran out. Then when he came back in, he started lashing out at me, which is why I tied him up. That's my story.
Okay, so he didn't choose to come down to your basement.
Well, I was performing an arrest on him. I doubt that any person getting arrested wants to be arrested.
And you're also saying that he lashed out at you. He was waving a knife.
He was.
Ma'am, you've had multiple interviews with the police.
I did.
Multiple opportunities to talk to them.
I did.
Multiple times they asked you about that night in the basement.
They asked me about that night. They didn't mention anything about Cotter Ashlock being violent, so I didn't mention it.
Not once did you think it was important to mention Cotter Ashlock was waving a knife?
I mean, they know he's a violent criminal. He's part of the Ashlock family. That's sort of standard for them.
So that's a yes. Not once did you think to mention a knife.
They didn't ask me, so I didn't tell them.
The first time we're hearing about that is in court today.
Yes, because he was waving a knife and I'm under oath. I have to tell the truth.
Objection, Your Honor. Pursuant to Koslowski v. Tilly, this is, Your Honor, this is against my witness's Fifth Amendment right. She has the ability to refuse statements.
Okay, and so you're saying that the questioning about her not discussing these events violates this case law?
Yes, Your Honor. Also, if we could real quick pause, my computer is about to die and it seems to be acting up.
All right, I hopefully the timing is paused anyway because this is an objection battle.
No, plug it in there. Right. This.
All right, I think we're ready to proceed, Your Honor.
Okay,
Sorry about that.
prosecution, do you have a response to this objection?
Yes, Your Honor. Before that, if our tech could actually pull up the specific wording of this case law. Your Honor, you'll notice it says here that it is a violation of the Fifth Amendment to suggest or state an adverse inference against a defendant for refusing to provide statements. Your Honor, we're talking about a lack of statements, not that the defendant was asked about it and refused to answer the questions, but calling into question why she never brought them up in the first place. That does not violate this case law at all.
All right, defense.
Yes, Your Honor, if this witness was never asked about these statements, then how is she expected to bring them up? That's the job of whoever's doing the deposition to ask her these questions. If this attorney wants to assert that she's guilty because, or she's wrong because she didn't say these to the police, it was the police's job to ask her these questions. Therefore, the members of the jury can't be asked to infer that my witness was lying by not bringing them up.
I don't think this necessarily violates this case law or the Fifth Amendment. I believe that it's just sort of going into the credibility or the bias of this witness. If you'd like to sort of expound on what the police did or didn't ask Miss Wölff in this case, that's perfect for a redirect. I'm going to overrule it this time.
Yes, Your Honor.
Yes, Your Honor. All right, so ma'am, when Cotter Ashlock was in your basement, you also asked some questions.
I did end up asking him a few questions.
You asked him questions about gang members.
I asked him questions about the Ashlock family.
Right, now the whole reason why you detained him in the first place was because he was breaking parole and following your neighbor.
Yes.
Not once did you ask any questions about your neighbor.
Charlie Reeves was safe inside of her house, and my priority was getting Ashlock to the police.
Okay, so it sounds like not once you didn't ask her why she was following your neighbor.
I don't need to ask a criminal why they were trying to hurt someone innocent. That's just standard for the Ashlock family.
But you found it important enough to ask about Jay Kuang.
I mean, that is a member of the Ashlock family, a criminal who killed someone, yes.
Right, the criminal that killed your best friend.
This has been established, yes.
Now, only after you ask your questions, then you call the police.
No. I called the police, and then in the time that they were taking to get there, I decided to ask Ashlock a few questions.
That's your story right now? You called the police?
Yes.
So you're saying you asked the questions after?
In the time that it took for the police to get to the scene, like the few minutes it did, I asked Ashlock whatever questions I had.
But I want to make it clear, you're not a police officer.
I'm a private investigator.
That means you're not a federal agent.
No.
Not a member of law enforcement.
Nope.
On March 11th, you were not responding to a call from the police.
Which call?
No officer asked you to detain Cotter Ashlock that day.
No, I'm a citizen, so I was performing a citizen's arrest. It's within my rights to do so.
So that's a yes. No officer asked you to detain Cotter Ashlock.
No. I don't need an officer to tell me to perform a citizen's arrest. I can do that myself.
Thank you, ma'am. Your Honor, nothing further.
All right, any redirect?
Yes, Your Honor, brief redirect. Now, Miss Wölff, why did you choose to make a citizen's arrest on Cotter Ashlock?
I saw Cotter Ashlock violating parole, and he was following after my neighbor. I knew I couldn't just let him keep walking on the streets after that.
And did you call the police when you got the chance?
I did.
Thank you, Miss Wölff. I have no further questions, Your Honor.
All right, defense, do you have any further witnesses?
No, Your Honor, the defense rests their case.
All right, then we've got another 5-minute break. We'll come back around 6:50. Are the prosecution and defense both back and ready to proceed?
The government's ready, Your Honor.
Yes, Your Honor.
All right, then with the record closed, we're ready to go into closing arguments. Prosecution, you guys have the floor.
Yes, Your Honor. She kidnapped to catch a killer. 2 hours. That's how long the defendant held Cotter Ashlock in her basement, threatening her for information, because she wanted revenge against the Ashlocks, so she kidnapped to catch a killer. Now, the defense tried to spin a story today about the defendant heroically helping the police take down the Ashlock family, almost like a vigilante protecting a town. But members of the jury, in the court of law, being a vigilante is illegal. Citizens are not allowed to interfere with police work, and certainly not tie up and threaten other people for revenge. She broke the law today because she kidnapped to catch her friend's killer. That's why today, as the state of Chile, we are charging the defendant for unlawful imprisonment. And that does mean we have a burden to prove beyond a reasonable doubt that Nova Wölff committed these crimes on March 11th, 2025. To meet this burden, there are two things we have to prove to you today. First, that the defendant, a civilian, interfered with an ongoing police investigation. So second, they could kidnap and restrain Cotter Ashlock. So first, let's talk about how she disregarded the police. You heard from the detective today that he warned the defendant this wasn't her case and that she should not get involved. But the defendant just wouldn't listen. She continued to investigate, misled the police, members of the jury. Citizens cannot take on the role of law enforcement. The officer today told you how much that interfered with their active police investigation they had against Cotter Ashlock. She got in the way, and that's against the law. So second, Mr. Ashlock was restrained. Because if there's one thing every single witness agrees today, it's that the defendant wanted revenge against the Ashlock family. And Ashlock killed the defendant's best friend, and she was willing to do anything to bring them to justice, even if that meant kidnapping and tying someone up. She kidnapped to catch a killer. Now, members of the jury, we met our burden today, but we're not the only ones who have one today. Because by choosing to pursue a citizen's arrest, the defense has taken upon themselves to prove something called an affirmative defense. We're going to focus on the most important prong of the affirmative defense that they have to prove. Nova Wölff contacted the police for a reasonable time after. We'll show you that he didn't. But first, let's address some of the promises the defense gave. Because earlier in opening statements, they promised to show you how biased the government's witnesses were today. They failed to do that because you met them. First, a police officer who has no stake in the case, who clearly explained the evidence, both the good and the bad. He didn't fight when some of the defense pointed out some of Cotter Ashlock's injuries were different, because that's what the evidence told him. Then Cotter Ashlock himself came up and explained his story. Not once was he inconsistent. The people you should watch out for, members of the jury, are the defense's witnesses. Because the neighbor admitted on cross-examination she was in court testifying for her good friend, the defendant. And then there's the defendant herself, who spun such an outlandish story. It's really funny that we're hearing it for the first time in court today. Because if there's one moment from this trial I want you to remember, that's the examinations of the defendant, when she started flat out making things up. She was interviewed several times by the police, and not once did she say the email shown to her wasn't hers. Not once did she talk about how aggressive Cotter Ashlock was when detaining him. She had all these opportunities to tell the police, and not once did she bring up him waving a knife in her face. That's someone who's making things up in court because they're desperate. And she kidnapped to catch a killer. Now, members of the jury, we're not here to force you to empathize with the Ashlocks. They've certainly done bad things. But we are here to defend the law. And no matter the reason, the law exists. And the defendant broke that law when she kidnapped to catch her friend's killer. Find the defendant guilty. Thank you.
Right, thank you, prosecution. Defense, do you have a closing argument?
Yes, Your Honor. Permission to proceed?
Whenever you're ready.
Nova Wölff drew the line. Now, today, the prosecution tried to tell you that she went too far. They tried to tell you a story of fear, a story of hate, a story of vengeance. But that's all that was. It was all just a story, because today we showed you what really happened. We showed you how when Nova's neighbor came to her door scared, Nova stepped up and did what was best for her community. She acted out of courage, out of friendship, out of justice. Now, today the prosecution chose to take up a burden, but not just any burden. They tried to prove their case to you beyond a reasonable doubt. That's the highest burden our law system has to offer. And they failed. Because to prove it to you, they tried to bring forward two main claims. First, that the defendant unlawfully locked someone in her basement. And second, that in doing so, she went against and interfered with law enforcement. But let's start with that first one, members of the jury, that Nova Wölff unlawfully locked Cotter Ashlock in her basement. You heard Cotter Ashlock testify. He tried to tell you that Nova Wölff hit him on the head, that she tied him up, even locked him in her basement. But you actually learned that Cotter Ashlock could have left that basement whenever he wanted to. That when the police found him, he wasn't even tied up. And that whole thing about being knocked out, the medical examiners found no trauma anywhere on Cotter Ashlock's head. Yet he still wants you to believe that he was knocked out by a hit even medical professionals couldn't find. But let's move on to that second part, that Nova Wölff interfered with law enforcement. But you learn Nova actually had a history of working hand in hand with the police department. She had actually helped them arrest people before. Nova even told you herself that when she subdued Cotter Ashlock, she called him the moment she had a chance. All she did was wait for him to calm down so no police would get hurt. But none of that matters because the prosecution had a smoking gun. They had emails, death threats sent to the Ashlocks by Nova Wölff. But hold on one moment, members of the jury, those emails don't add up. On one hand, we have Nova Wölff's email address. And on the other, death threats sent by a completely different person. Now, the prosecution may have failed to meet their burden today, but don't worry, we actually expected them to. That's why we took on our own burden. That's why we chose to prove our case to you with a preponderance of the evidence. All we had to do was prove our case 51%. And think of it just like Miss Sessa said earlier, think of it like a scale. If we even tip that scale slightly in our favor and prove to you that Nova Wölff acted lawfully that night, then we met our burden. And we did, because today you learned about a citizen's arrest, a right granting anyone the ability to subdue someone else suspected of committing a crime. The only caveat being, the force used in that moment should be deemed necessary by the situation. And luckily for Nova Wölff, she knew where to draw the line. So when her neighbor ran up to her doorstep, scared, saying someone had been following her, Nova stepped up. She said she'd go check it out. And when she did, she found it was none other than Cotter Ashlock breaking the rules, violating parole. So she made a citizen's arrest. But she didn't overstep her boundaries. She acted within her rights, and she protected her community. But Cotter Ashlock tried to tell you Nova Wölff was the violent one that night. But you heard her testify. She told you how Ashlock was going crazy, trying to threaten her with a knife. And despite all that evidence, Ashlock still wants you to believe that Nova beat him up, that Nova smashed his phone, that Nova threatened him with a knife. But you learned about the bruise marks on Cotter Ashlock's fists. Bruise marks he got from hitting someone. The phone he said Nova Wölff smashed against the wall had only one person's fingerprints on it, Cotter Ashlock's. The knife he said Nova Wölff threatened him with had only one person's fingerprints, Cotter Ashlock's. All the evidence in today's case points to one person crossing the line, Cotter Ashlock. He violated parole, he violated the rules, and he broke the law. He even lied to you, members of the jury. But while Cotter Ashlock was crossing the line, Nova knew where to draw it. She chose not to return violence with more violence. She acted reasonably, and she protected her community. And I want you to remember that. To remember who crossed the line and who drew it when you're deliberating today's case. Because if you follow the evidence, it'll lead you to one choice: to find Nova Wölff not guilty.
All right, thank you, defense. Prosecution, do you rebuttal?
Yes, Your Honor.
All right, feel free to go whenever you're ready.
She kidnapped to catch a killer. Now, the defense keeps saying that the defendant drew the line. But the truth is, members of the jury, she crossed that line. She crossed that line when she interfered with law enforcement, impeding the officer's active investigation. She crossed that line again when she kidnapped Cotter Ashlock and held him in her basement. Now, the attorney just said that Cotter Ashlock could leave whenever he wanted to. Well, that directly contradicted what the defendant said just minutes ago on stand when she explained that she tied him up and kind of pushed him into the basement, gave him no choice whatsoever. And the defense also just described the emails as smoking guns. If they came from the defendant. They did. Members of the jury, they came from someone called N. Wolf, even with the 2 dots on top of the O, from the best friend of the man you murdered in cold blood. Does that sound familiar? That's the defendant again. She was showed this very email by the police and never said it wasn't. She had multiple opportunities to explain. Never did she say somebody might be impersonating this account. Inconsistency after inconsistency, from the emails to the knife, it is clear the defendant is making things up. She's doing that because she knows she kidnapped to catch her friend's killer. And that's against the law. Find her guilty.
All right, thank you very much. All right, we're going to give the scores here a moment to finish up their notes. And if we could get both sides just putting in sort of a list of the attorneys and witnesses in the order they went, sort of open, P witnesses, D witnesses, and then closers, just each side.
Just to clarify, is that the order they testified in, Ashlock and then Capolino? My notes are incomplete about who was doing what when.
I believe Capolino was first. And then defense, can we get your guys' names too, just to make sure I got everything correct?
Yes, Your Honor, I'm typing it out right now.
All right, oh, there we go.
First ballot is received from Judge Kim. Thank you. Second ballot is received. Thank you. All 3 ballots are in. Feel free to proceed with comments.
Okay. I'll do the classic mock trial judge thing and say you've been hearing from me long enough, so I'll pass it to my scoring judges, the jury who have been silent throughout this trial.
I'll go first. You guys all did so amazing. Sorry, let me know if you can hear me okay. You guys did so amazing. I can see all of the effort and all the work and all the preparation that's gone into this. You guys are amazing. You should be so proud of yourselves. As for feedback, I think I have the unique perspective. I'm not sure about Davia, but I knew nothing about this case going into it. And so something I would definitely watch out for is looking at this from someone who has never seen this case before, because you get the hang of it as stuff goes on, but especially in openings, if you're throwing a lot of names at me, it's kind of hard to keep track of them all. And so I think signposting is important there, and also just making sure you're really explaining it thoroughly. But you guys are amazing. Oh, also watch out for those lack of foundation and spec objections, because there was a lot throughout this trial, and that kind of again goes with me having never seen this case before. A lot of stuff that you guys probably oh, everybody knows this because it's such a big thing in the case. I have no idea. So yeah, just stuff like that. But I thought you guys were amazing, and you should be so proud of yourselves. It's a really fun round. Good job, guys.
I echo what Kayla was saying. This was really fun to watch. It's clear that you all were really prepared and excellent. And those are always the most fun rounds, at least for me to watch. A few things just sort of carrying forward. Video is a really difficult format to do mock trials in, and it is totally different than doing them in a courtroom or a classroom. And the biggest things for me on that are all of your movements are exacerbated in video format, and your volume control needs to look different when you're in a video format, because some people are listening through headphones, some people are not. So you're dealing with ambient noise, but you're also dealing with microphones, which just affect the way that noise is coming through. So you have all obviously put a ton of practice into this. If you are not already, I would practice through video and record through video so that you can see how that sounds and how it looks when you're in this close-up format. A big thing that happened a few times is you can tell your neutral stance is different on video than it is when you're in person, because so many of your hand movements are in this area. And if they're right on that camera line, it is more distracting than when you're in person and maybe you have a neutral stance that might have your arms up a little bit. So I would really caution that. And when you're making movements, make strong movements, because you can also see if you're making a movement here and you're pulsing your hand, that comes off very differently over video than when you're in person. So just be aware of the differences in format. It's really difficult to adapt. You all are doing a really great job, but that's something that I think can help on a moving forward basis. I took way more extensive comments on the ballot that you'll see later. But yeah, really impressed.
Yeah, so the scoring judges said a lot of really good stuff. Again, I just want to commend you guys. I sucked when I was in high school at mock trial, so you guys are in a way better place than I was in. And then also got a lot of comments, a lot of specific comments in the form. So if there's anything that doesn't make sense, I'm in the IMT Slack. Just you can ask me any question that you want. Biggest feedback I think is overall in the case, because you guys don't have a lot of time, especially on statements, less is actually more. So I know this is kind of a, you want to have a lot of stuff in the case, but the more things that you talk about, the faster you need to talk and the more you need to say and the more you might forget and the less you can actually talk about each exhibit. And the great thing about mock trial is you don't actually have to meet your burden, especially on prosecution. And so you don't necessarily have to have a watertight ship. You can have one that is a little bit more presentationally good. And this is not a knock to like prosecution specifically. I'm just, you guys are the ones who normally have a burden. So I would just try to focus on things that are a little bit more substantive to your case and things that you can carry out throughout the whole trial and come back to instead of really small arguments that might happen maybe once. Another big thing is the law. So I'm kind of going to get a little nitpicky just because I'm familiar with the case. Um, I kind of didn't understand what the law was based on what you guys are explaining. I know law is kind of difficult to understand, but especially when you're doing an affirmative defense for like a citizen's arrest, there are like specific prongs that you guys need to get at. That someone has to be committing a felony. Was Cotter Ashlock committing a felony? Did Nova Wölff know about that? And then what's reasonable force? You guys have to sort of argue about that. And then for prosecution, it's sort of like impeding, an officer is not necessarily just interfering with an investigation. You actually have to like meaningfully obstruct something, right? So that's not saying that you guys did poorly or I like, scored you down for anything like that. But it can be a little bit more helpful to the jury when you're listening throughout trial to be like, oh, this is what I need to understand for the law. Like, this is why it's important, right? So again, nothing, I didn't like give everybody like anything terrible for that. Just saying more explanation of the law is always more helpful. And then last thing, new objection for you guys, 704, okay? Witnesses are not allowed to make what's called an opinion on the ultimate issue, and that's the sort of verdict in the case. So a witness can't say, yeah, she was committing a citizen's arrest, or she wasn't committing a citizen's arrest, or she is guilty, right? That's only for the jury to decide. So go in, look at 704. I know you guys were sort of like catching on that was like something that probably shouldn't happen, but you didn't know what rule it fell under. 704, that's going to be your best friend. And just make sure you sort of stray away from that as a witness. But overall, a lot of really good stuff. I didn't even know what hearsay was in high school. So the fact that you guys are now looking at like 704 and all these other stuff, like really good job, guys. You did awesome.
All right, folks, we've got these results in. The first thing we do is announce the MVPs for attorney and witness. We're going to begin with the attorney MVP. By unanimous decision, your MVP in the first quarterfinal from the prosecution, Ms. Anya. There was a split decision for MVP witness, but winning the split decision from the defense, Noor Khan. This takes us to the ultimate results, which were also a split decision. Congratulations to both teams, but advancing with a record of 2 wins, +3, +4, and 1 perfect tie, 0, the prosecution. Congratulations to both teams. You're going to get these ballots basically immediately over Slack. Well done to all. Thank you, judges, and thank you, William, for hosting.